Welcome! In this video, we will discuss investor-state arbitration, which is gaining an increasing importance in international litigation. I am sure that you have already heard about investor-state arbitration, even if you may not realize it. For instance, the current negotiations between the United States and the European Union on the Transatlantic Trade and Investment Partnership, known as the TTIP, and the Australian Tobacco Plain Packaging Act, which standardizes cigarette packages. Both those situations relate in one way or another to investor-state arbitration. In this video, we will focus on the main aspects of investor-state arbitration. How did it emerge? What is the object of the dispute settlement, and how does investor-state arbitration work? What are the criticisms faced by this type of arbitration? Let's start our journey. Investor-state arbitration is not as old as interstate arbitration, which is discussed in video 2. It emerged during the 20th century as a substitute for domestic tribunals and diplomatic protection to settle the disputes between foreign investors and host states. The main objective of the recourse to arbitration was to depoliticize the settlement of investor-state disputes, which were viewed as overly political. As a matter of fact, the domestic tribunals of host states were perceived as being biased and lacking independence for the benefit of these host states. As to diplomatic protection, the discretion of the exercise of this protection by the home states of investors, depending on their own interests, created unpredictability and insecurity for these investors. As a result, arbitration was increasingly incorporated into contracts concluded by states and foreign investors regarding specific investment operations, for instance, oil concessions. Nowadays, investor-state arbitration is mainly used to settle disputes arising from bilateral and multilateral investment treaties concluded between states. More than 3,000 bilateral investment treaties are currently in force. These treaties grant rights to the investors of states that invest in another state party. It is the case, for instance, of Canadian investors investing in Mexico under the North American Free Trade Agreement. Under this agreement, and investment treaties more generally, foreign investors have especially the right to be treated fairly and equitably, the right not to be discriminated, or the right not to have their property expropriated without compensation. When an investor considers that its rights have not been respected and that the host state has breached its treaty obligations, it can bring a claim. It can do so because state parties themselves traditionally give their consent to the settlement of investor-state disputes for arbitration in the investment treaties, be they bilateral or multilateral. In investment treaty arbitration, the consent of the parties to the dispute is not given at the same time. For the sake of clarity, I will take the example of bilateral investment treaties to explain this, but you should know that the functioning is similar for multilateral investment treaties. So, in these bilateral investment treaties, two states give their consent in advance with respect to the investors of the other state party to the treaty. In turn, this investor gives their consent, individually or collectively, at the later stage, when they submit their claims through the request for arbitration. Arbitration is currently the main method to which states consent for the settlement of the investor-state dispute arising from the bilateral and multilateral treaties to which they are parties. While it is the main method used to settle investor-state disputes, arbitration is currently facing much criticism, coming not only from NGOs, but also from an increasing number of states. One criticism relates to the issue of consent that I have just addressed. Because state parties to bilateral investment treaties, for instance, give their consent to arbitration in advance with respect to all the investors of the other state party investing in their territory, and because foreign investors can then express their consent unilaterally, these investors can try to constrain the regulatory power of these states. Indeed, they can threaten to initiate arbitration with respect to measures that negatively impact their investment, with the view to lead states to withdraw or not to adopt these measures. Of course, these investors have no guarantee that they will win the case. But what remains is that the prospect of a costly arbitration proceeding and the risk of having to compensate these investors can lead some states to refrain from regulating, often to protect or promote public interests. This brings us to the main criticism currently faced by investor-state arbitration. It relates to the public dimension of the object of investor-state disputes and the original private nature of investor-state arbitration. At the outset, investor-state arbitration was modeled on commercial arbitration. This means that the proceedings were confidential. For instance, the hearings were not public, and the awards were not released. Another related feature of arbitration which is contested concerns the fact that arbitrators are private persons who are said to be lacking any representativeness. Overall, arbitration appears to many as an illegitimate method to settle investor-state disputes in which the public interests of local populations are so important. In this video, you have learned about the history and the basic functioning of investor-state arbitration. You have also discovered the criticism faced by this type of arbitration. I invite you to watch video 4, which discusses a dispute currently being settled under the auspices of the Permanent Court of Arbitration. This is a dispute between Philip Morris Asia and Australia, which relates to the measures decided by Australia to reduce smoking and its effects on public health. This will allow you to form your own opinion on the adequacy and legitimacy of investor-state arbitration to decide disputes in which your public interest is at play. Thank you for watching.